Welcome to Daily News Simplified, an answer to what, why, and how of newspaper reading. Today, we'll be discussing the important news appearing in the Hindu newspaper dated 6 August 2019. The news to be discussed has been presented on the screen, and timestamping for the same has been provided in the description box below. So, let's start our today's discussion. Now, continuing our series of question discussions of pre 2019, today we'll discuss a question on CAMPA. The question asked in the prelims of 2019 was: consider the following statements. As per law, the Compensatory Afforestation Fund Management and Planning Authority exists at both national and state levels. This was the first statement. The second statement was: people's participation is mandatory in the compensatory afforestation programs carried out under the Compensatory Afforestation Fund Act of 2016. Now, as you can see, we had discussed this news on CAMPA, which appeared on 18th October 2018. The news which appeared was: Supreme Court bars states from diverting money from CAMPA funds. Hence, this news was covered where we discussed certain basic facts with respect to CAMPA funds. As you can see, it has been mentioned that CAMPA funds is basically meant for afforestation purposes. Now, while discussing the salient features of this act, we mentioned very specifically that the creation of funds is both at national level as well as state level. So, this fund was to be established in each state as well as union territory. And this fund was to compensate loss of forest land diverted for non-forest purpose. So this was also mentioned as part of the bill. Further, we also discussed that the bill seeks to create a national compensatory forest fund management and planning authority, again both at national level as well as state level. So we had discussed about CAMPA. We also discussed that the fund which was to be established at national level was to be done under Public Accounts of India, and the fund at state level was to be done at Public Accounts of, and further these funds was to be used for various afforestation initiatives. However, nowhere we had mentioned that mandatory participation of people was required or a necessary requisite of this particular bill or this particular act. So, coming back to this question as asked by UPSC, we find that statement 1 is correct, as the Compensatory Afforestation Fund Management and Planning Authority exists at both national and state levels. As you can see, it has been mentioned here specifically that the authority is to be established at national as well as state levels. And the second statement becomes incorrect because it states that people's participation is mandatory with respect to compensatory afforestation as per this act. Hence, in this question, A was the correct answer, that is, one only. So, after this discussion, let's move on to our daily news analysis. Now, as you are aware about yesterday's big development with respect to the state of Jammu and Kashmir, so today's newspaper is filled with the entire issue of dividing the state of Jammu and Kashmir into two union territories, into the union territories of Jammu and Kashmir as well as Ladakh. Before going through the newspaper on the issue of Kashmir, let us first of all understand the various bills and resolutions introduced by the Home Ministry of India. It says that the Union Minister for Home Affairs, Shri Amit Shah, introduced two bills and two resolutions regarding Jammu and Kashmir, and these are: first, Constitution application to Jammu and Kashmir Order of 2019 issued under Article 370 Clause 1 of the Constitution of India, and this was issued by the President of India to supersede the previous order of 1954 related to Article 370. The next resolution is with respect to resolution for repeal of Article 370 of the Constitution of India, again under Article 370 Clause 3 of the Indian Constitution. Next, it talks about two bills. First, the Jammu and Kashmir Reorganization Bill of 2019, and this has been referred under Article 3 of the Indian Constitution, and Jammu and Kashmir Reservation Second Amendment Bill of 2019. So these are the important bills and resolutions as moved by the Honorable Home Minister yesterday with respect to Article 370, which provides special status to the state of Jammu and Kashmir. The news on the first page reads: Jammu and Kashmir loses its special status, divided into two union territories. and this becomes important for us with respect to our UPSC examination, both from prelims as well as mains examination under GS paper 2. Now, the first page of this newspaper mentions that Home Minister Amit Shah announces the centre's decision in Raj Sabha with respect to removing the special status as provided to the state of Jammu and Kashmir under Article 370 of the Indian Constitution. It says that Raj Sabha adopts the Jammu and Kashmir Reorganisation Bill with 125 votes in favour and 61 against. So again, from an examination perspective, the Jammu and Kashmir Reorganisation Bill of 2019 becomes extremely important as it divides the state of Jammu and Kashmir into the union territories of Jammu and Kashmir on one hand and Ladakh on the other hand. Now, important point to be noted is that the Union Territory of Ladakh will not have any legislative assembly, whereas the Union Territory of Jammu and Kashmir will have a legislative assembly on the likes of Delhi. Further, the news on page 1 also mentions about Article 370. It says that under Article 370, Jammu and Kashmir had its own constitution and the laws passed by the parliament were applicable to the state only with the state government's concurrence. Now, under Article 370, the President of India is empowered to issue presidential order. So, on this note, it says that the President was empowered to decide which provisions of the Indian Constitution would be applicable with the state's accent, that is, approval by the state legislature. Now, the removal of special status under Article 370 has also impacted Article 35A, which was added to the Indian Constitution not through an amendment under Article 368 but through a presidential order of 1954. It says that Article 35A protected the laws such as bar on outsiders buying property in the state and women marrying non-Kashmiris losing their property rights. So after removing this special status of Jammu and Kashmir under Article 370, Article 35A no longer exists. So from now on, any person from outside the state of Jammu and Kashmir can buy property in Jammu and Kashmir as well as Ladakh. So as you can see in this particular map, this is the division of the state of Jammu and Kashmir into the two union territories of Jammu and Kashmir as well as Union Territory of Ladakh. Now this news also appears on page number 12 where it reads, Opposition divided, Raj Sabha passes bill. You must understand that this is a very politically sensitive issue and different members of the parliament have expressed their own viewpoint with respect to removal of special status from state of Jammu and Kashmir. However, from an examination perspective, we must understand about the Jammu and Kashmir Reorganisation Bill of 2019. Now further, page number 13 provides for two important news. First, it says how Jammu and Kashmir status is being changed, and the second news is with respect to what the repeal of Article 35A entails. Hence, both these news becomes important for us to understand and analyze. Now moving ahead, on page number 10, this news is covered in the editorial section and also as a part of lead article. In the editorial, it says that a wrong way to end. The special status of Jammu and Kashmir was never meant to be permanent, but it should not have been scrapped without wider consultation. Whereas this lead article mentions about piecing together Kashmir's audacious roadmap, where it says that a new doctrine will have to persuade Jammu and Kashmir that greater integration with India holds promise. Further, another important article appears on page number 10. It says an integration without integrity, where it mentions that more than forced homogenization with India, Kashmir needs a moral disposition towards truth and honesty. So we understand that this entire issue of removal of special status of Jammu and Kashmir under Article 370 has been covered across the Hindu newspaper. So in today's analysis, we'll try and understand what these important articles have to say and what are the important issues which have been raised with respect to first, removing special category status of Jammu and Kashmir under Article 370 and also with respect to creation of two new union territories through the Jammu and Kashmir Reorganisation Bill of 2019. Now, before going to the analysis of this entire news, let us understand that why this topic is important for us from a UPSC perspective. As you can see, in the year 2016, in GS paper 2, this question was asked. The question was, to what extent is Article 370 of the Indian Constitution bearing marginal note temporary provision with respect to state of Jammu and Kashmir temporary? Discuss the future prospects of this provision in the context of Indian polity. And this question was to be written in 200 words. Now let's go through why this topic is important. First of all, it talks about political integration of Jammu and Kashmir with the rest of India by removing the special status provided to the state. Then it says that the special status of Jammu and Kashmir under Article 370 has been removed. Then all provisions of the constitutions to be applicable on Jammu and Kashmir. For example, Article 360, that is financial emergency, was not applicable to state of Jammu and Kashmir. It further says that state of Jammu and Kashmir to be divided into two union territories, which we have already seen. Further, Jammu and Kashmir Reorganisation Bill of 2019. Then it mentions about removal of Article 35A of the Indian Constitution, which was added by a presidential order of 1954. It then says that because of this division of state of Jammu and Kashmir into union territories, there will be an amendment or change in Schedule 1 of the Indian Constitution. Further, instrument of accession also gains importance, which was signed between the Government of India and Maharaja Hari Singh of Jammu and Kashmir. Then it says that change of tenure of Legislative Assembly of Union Territory of Jammu and Kashmir, which will have a Legislative Assembly, to 5 years. Because as of now, the tenure of Legislative Assembly of the state of Jammu and Kashmir is for 6 years. So all these aspects becomes important from a UPSC perspective. So in this backdrop, let's start our discussion by understanding Article 370 of the Indian Constitution. Now as you can see, Article 370 of the Indian Constitution is covered under Part 21, which provides for temporary, transitional and special provisions. And specifically Article 370 mentions about temporary provisions with respect to state of Jammu and Kashmir. Now if you go through the question asked by UPSC in 2016, it states, to what extent is Article 370 of the Constitution bearing marginal note temporary provision with respect to the state of Jammu and Kashmir temporary? So even UPSC has emphasized on this aspect of temporary provision of Article 370. Now there are few important aspects to be understood with respect to Article 370. We know that Parliament has power to make laws as mentioned in the Union List and concurrent list of the 7th schedule to the Indian Constitution under Article 246. However, the Parliament of India cannot make laws on all the entries of Union List as well as concurrent list for state of Jammu and Kashmir, as the Parliament is empowered to make laws for other states. And this restriction on the Parliament of India to make laws on all the entries of Union List and concurrent list was restricted by Instrument of Accession signed by the then Maharaja of Jammu and Kashmir with the Government of India. So, Article 370 specifically mentions that the power of Parliament to make laws for the said state shall be limited to, first, those matters in the Union List and the concurrent list which, in consultation with the government of the state, are declared by the President to correspond to matters specified in the Instrument of Accession. So first point is that the Parliament of India has to make laws under Union List as well as concurrent list with consultation or in consultation with the state of Jammu and Kashmir. And secondly, the points on which or the entries on which the Parliament was making law must correspond to the matters as specified in the Instrument of Accession. Hence, the Parliament enjoyed limited powers with respect to making laws for the state of Jammu and Kashmir under Union List as well as concurrent list. Now, another point highlighted in Article 370 was that the Parliament must take the concurrence of the state of Jammu and Kashmir in order to make any law under Union List or concurrent list. So, consultation as well as concurrence became a key aspect of Article 370, and this consultation and concurrence with respect to matters corresponding to Instrument of Accession somewhat limited the powers of Parliament to make laws for the state of Jammu and Kashmir. So this was the special status provided to the state of Jammu and Kashmir. However, clause 3 of this article gives the President the power to seize this article, because anyways this article was incorporated in the Indian Constitution as a temporary provision. So Article 370 clause 3 states that the President may by public notification declare that this article shall cease to be operative or shall be operative only with such exceptions and modification from such date as he may specify. So we understand that the power to remove this article has also been given in this article itself under Article 373, as it clearly states that the President may by public notification declare that this article shall cease to be operative or shall be operative only with such exceptions and modifications from such date as the President may specify. So these are the important aspects of Article 370 which you must understand before going through yesterday's decisions taken by the Government of India with respect to removing special status of Jammu and Kashmir under Article 370. This article appears on page number 13. It says how Jammu and Kashmir's status is being changed. Provisions forming the basis of separate constitution annulled. Now this particular news highlights that the President of India has promulgated the Constitution application to Jammu and Kashmir order of 2019, and this has been done in concurrence with the state government of Jammu and Kashmir with immediate effect. Now we know that as of now the Legislative Assembly of Jammu and Kashmir has been dissolved and the state is under President's rule under Article 356. So the 2019 presidential order was promulgated in concurrence with the governor of the state. It further mentions that the 2019 presidential order supersedes the Constitution application to Jammu and Kashmir order of 1954, and also states that all provisions of the Constitution of India shall apply to the state of Jammu and Kashmir at once. So this is the context of this particular news mentioned on page number 13. Further, the Presidential Order of 1954 listed all the articles and provisions which were applicable to the state of Jammu and Kashmir, and these special measures could be altered only on the recommendations of Sadr-e Riyasat of Jammu and Kashmir, acting on the aid and advice of Council of Ministers, or by the Constituent Assembly of the state of Jammu and Kashmir. Now we know that the Constituent Assembly of the state of Jammu and Kashmir no longer exists. Hence, the Presidential Order of 2019 uses the word with the concurrence of the government of state of Jammu and Kashmir. So basically this means the concurrence has been taken from the governor of the state of Jammu and Kashmir, who as of now is administering the state which is under President's rule with respect to Article 356, and it is the governor who has given his concurrence on behalf of the state government for the President to issue a proclamation under Article 370 Clause 1. It further highlights that the 2019 presidential order supersedes the 1954 order, and this effectively means that all the provisions that form the basis of a separate constitution of Jammu and Kashmir now stands abrogated or annulled. And this 2019 presidential order declares that all provisions of the Constitution of India shall apply to the state of Jammu Kashmir as well, just like any other state. So, the Presidential Order of 2019 basically provides for the political integration of the state of Jammu and Kashmir with the rest of the Union. Now, to completely scrap Article 370 of the Indian Constitution, few clauses were added in Article 367 of the Indian Constitution. And these new clauses in Article 367 contains interpretation, where they contain guidance as to how to read or interpret some of the provisions of the Constitution. Now, with respect to the new clause, it says, when applicable to Jammu and Kashmir, all references to the Sadr-e Riyasat acting on the aid and advice of the Council of Ministers shall be construed as reference to the Governor of Jammu and Kashmir. So, wherever the word Sadr-e Riyasat has been mentioned with respect to acting on the aid and advice of Council of Ministers, the word Sadr-e Riyasat must be construed as Governor of Jammu and Kashmir. Further, all references to the state government shall mean the governor of the state. Further, all references to the Constituent Assembly as provided under Article 370 Clause 3 must be referred as Legislative Assembly of the state. Since the Constituent Assembly of Jammu and Kashmir no longer exists, hence its role has to be played by the Legislative Assembly of the state of Jammu and Kashmir. So these are the few clauses which have been added to Article 367 for the purpose of interpretation, where Sadr-e Riyasat will be interpreted or read as Governor of Jammu and Kashmir, state government shall be read as the Governor, as well as Constituent Assembly as mentioned under Article 370 Clause 3 shall be read as Legislative Assembly of the state. So these are some of the legal changes as provided through the Presidential Order of 2019. Now moving on, let's discuss some of the important provisions of the Jammu and Kashmir Reorganization Bill of 2019. Now first of all, let's understand about the statement of objects and reasons. So with respect to creating the Union Territory of Ladakh, the statement of object and reasons of this particular bill states that the Ladakh division of the state of Jammu and Kashmir has a large area but is very less populated or is sparsely populated with a very difficult terrain. And in this aspect, there has been long pending demand of the people of Ladakh to give it the status of Union Territory so as to enable them to realize their aspirations. Thus, the Government of India created a Union Territory of Ladakh, keeping in mind the long pending demand of the people of Ladakh to give it the status of a UT in order to realize their aspirations politically, socially, as well as economically. Now, considering the prevailing internal security situation fueled by cross border terrorism in the existing state of Jammu and Kashmir, the Government of India thought it wise to create a separate union territory for the Jammu and Kashmir. And it further states that the Union Territory of Jammu and Kashmir will be with a legislature. So this is basically the statement of object and reasons with respect to the Jammu and Kashmir Reorganization Bill of 2019. Now, let us also go through some of the other important provisions of this Reorganization Bill of Jammu and Kashmir, which becomes important from our prelims and mains perspective. It mentions about formation of Union Territory of Ladakh without legislature, formation of Union Territory of Jammu and Kashmir with legislature, and governor of existing state of Jammu and Kashmir to be common lieutenant governor. Now, this becomes important to understand from your prelims perspective. It states that the governor of the existing state of Jammu and Kashmir shall be the lieutenant governor for the Union Territory of Jammu and Kashmir and Union Territory of Ladakh for such period as may be determined by the President. So this becomes important that the governor of the existing state of Jammu and Kashmir shall be the lieutenant governor for both the Union Territory. Now another important aspect to be highlighted is that the Union Territory of Ladakh will comprise the districts of Kargil as well as Leh, and the remaining of the area will comprise under the Union Territory of Jammu and Kashmir. Now another important aspect highlighted in this bill is with respect to amendment of the first schedule to the constitution as well as amendment of the fourth schedule to the Indian Constitution. The first schedule of the Indian Constitution mentions about the name of states as well as union territories, and the fourth schedule mentions about allocation of seats in the Council of States, that is Rajya Sabha. Now another important aspect deals with representation in House of the People, delimitation of parliamentary constituencies, as well as applicability of Article 239A of the Constitution. Now as you can see, Article 239A of the Indian Constitution mentions about creation of local legislatures or Council of Ministers or both for certain union territories. So it says that on and from the appointed day, the provisions contained in Article 239A which are applicable to the Union Territory of Puducherry shall also apply to the Union Territory of Jammu and Kashmir. With respect to representation in House of People, it states that on and from the appointed day, there shall be allocated 5 seats to the successor Union Territory of Jammu and Kashmir and 1 seat to the Union Territory of Ladakh. So in this point, you need to remember that 5 seats to be allocated in Lok Sabha to the successor territory of Jammu and Kashmir and 1 seat to the Union Territory of Ladakh. And to make this accommodation, the first schedule to the Representation of People Act of 1950 shall also be amended accordingly. So basically, we also see an amendment being proposed under Representation of People Act of 1950. Now another important aspect highlighted in the reorganization bill is with respect to Legislative Assembly for the Union Territory of Jammu and Kashmir and its composition. It states that there shall be an administrator appointed under Article 239 of the Constitution of India for the Union Territory of Jammu and Kashmir and shall be designated as Lieutenant Governor of the said Union Territory. And it further states that the total number of seats in Legislative Assembly of the Union Territory of Jammu and Kashmir is to be filled by persons chosen by direct election, and the number of assembly seats shall be 107 for UT of Jammu and Kashmir. Now another important aspect highlighted here is with respect to number of seats under Pakistan occupied Kashmir or occupation or those area under the occupation of Pakistan. It mentions that there would be 24 seats under the Pakistan occupied Kashmir, and it mentions that until the area of Union Territory of J&K under the occupation of Pakistan ceases to be so occupied and the people residing in that area elect their representatives, 24 seats in the Legislative Assembly of Union Territory of Jammu and Kashmir shall remain vacant and shall not be taken into account for reckoning the total membership of the assembly. So basically it states that unless election takes place in this area, 24 seats shall remain vacant and shall not be taken into account while counting the total number of membership of the assembly. And it further mentions that this area and seats, that is this 24 seats, shall be also excluded in delimiting the territorial constituencies. So the number of seats under Pakistan occupied Kashmir, that is 24, shall neither be taken into account for reckoning the total membership of the assembly, as well as it shall be excluded in delimiting the territorial constituencies. Now, Schedule 3 of the Reorganisation Bill of Jammu and Kashmir provides for amendments to the Delimitation of Assembly Constituencies Order of 1995. It says that on and from the appointed day, the Delimitation of Assembly Constituencies Order 1995 as applicable to the UT of Jammu and Kashmir shall stand amended as directed in the third schedule of this Act. Further, another important aspect highlighted in this reorganization bill is that it says that seats shall be reserved for scheduled caste and scheduled tribes in the Legislative Assembly of the Union Territory of Jammu and Kashmir. Now, this becomes a very important aspect to be remembered from your prelims perspective. So, it mentions about reservation of seats in the Legislative Assembly of UT of Jammu and Kashmir for members of scheduled caste as well as scheduled tribes. Another important provision is with respect to representation of women and qualification for membership of Legislative Assembly. It mentions that the Lieutenant Governor of the successor UT of Jammu and Kashmir may nominate 2 members to the Legislative Assembly to give representation to women. So we understand that the Lieutenant Governor of Jammu and Kashmir can appoint 2 women to the Legislative Assembly of UT of Jammu and Kashmir in case of inadequate representation of women in the Legislative Assembly. With respect to qualification, it says that a person shall not be qualified to fill a seat in Legislative Assembly unless he is a citizen of India and makes and subscribes before some person authorized in that behalf by the Election Commission an oath or affirmation according to the form set out for the purpose in the 4th schedule of this Act. Further, he is not less than 25 years of age and possesses such other qualification as may be prescribed in this behalf by or under any law made by Parliament. So basically, the Parliament can make a law with respect to qualification for membership of Legislative Assembly of Union Territory of Jammu and Kashmir. This becomes an important aspect to be remembered, that he shall be a citizen of India and he shall not be less than 25 years of age. Now, another important aspect highlighted is with respect to Council of Ministers. It states that there shall be a Council of Ministers consisting of not more than 10% of the total number of members in the Legislative Assembly of UT of Jammu and Kashmir, and the Chief Minister shall be at the head to aid and advise the Lieutenant Governor in exercise of his functions in relation to matters with respect to which Legislative Assembly has power to make laws, except, that is, there is a provision of exception insofar as he is required by or under this Act to act in his discretion. So we see that the Lieutenant Governor does enjoy certain discretion with respect to aid and advice of the Council of Ministers in the Legislative Assembly of UT of Jammu and Kashmir. Now, it highlighted certain important discretion of the LG. It states that the Lieutenant Governor shall, in exercise of his functions, act in his discretion in a matter which falls outside the purview of the powers conferred on the Legislative Assembly, that is, on those matters in which the Legislative Assemblies do not have any power, or in which he is required by or under any law to act in his discretion or to exercise any judicial functions. Further, if the matter is related to All India Services and Anti-Corruption Bureau. So these are the aspects which has been specifically provided with respect to the discretionary function of the Lieutenant Governor of UT of Jammu and Kashmir. So these becomes important aspects for you to be remembered from your upcoming prelims examination. Moving ahead, it also mentions about the appointment of chief minister and other ministers. It says that the chief minister shall be appointed by the lieutenant governor and other ministers shall be appointed by the lieutenant governor on the advice of chief minister. Further, it mentions that the ministers shall hold office during the pleasure of the lieutenant governor, and the council of ministers shall be collectively responsible to the legislative assembly. This becomes an extremely important point with respect to our parliamentary democracy. With respect to oath, it states that before a minister enters upon his office, the lieutenant governor shall administer to him the oaths of office and of secrecy, according to the form set out for the purpose in the fourth schedule. Another important aspect highlighted is with respect to the salaries and allowances of ministers, which shall be such as the legislative assembly may from time to time by law determine, and until the legislative assembly so determines shall be determined by the lieutenant governor. So their salaries shall be determined by a law made by the legislative assembly. Moving further, another important aspect highlighted is with respect to the duties of chief minister with respect to furnishing information to the lieutenant governor. It states that it shall be the duty of chief minister to communicate to the lieutenant governor all decisions of the council of ministers relating to the administration of the affairs of the union territory and proposal for legislations, and also furnish such information relating to the administration of the affairs of the union territory and proposal for legislation as the lieutenant governor may call for. So these becomes important duties of the chief minister with respect to furnishing information to the lieutenant governor. Now another important point which you must remember from your prelims perspective is with respect to appointment of LGs of Union Territory of Ladakh. It states that the Union Territory of Ladakh will be administered by the President acting to such an extent as he thinks fit through a Lieutenant Governor to be appointed by him under Article 239. Now this becomes important because Union Territory of Ladakh will not have a legislative assembly. Hence, the UT of Ladakh will be administered by the President through the Lieutenant Governor, which again will be appointed by the President of India under Article 239 of the Indian Constitution. It further states that the President of India may make regulations for peace, progress, and good government of the Union Territory of Ladakh under Article 240 of the Constitution of India. Another important point highlighted is that the LG shall be assisted by advisors to be appointed by the central government with respect to administration of Union Territory of Ladakh. So these becomes important points with respect to administration of Union Territory of Ladakh. It further mentions about the applicability of Scheduled Caste Order as well as Scheduled Tribes Order. It states that on and from the appointed day, the Constitution, Jammu and Kashmir Scheduled Caste Order 1956 shall stand applied to the Union Territory of Jammu and Kashmir and UT of Ladakh. Similarly, with respect to the Constitution of Jammu and Kashmir Scheduled Tribes Order 1989, which shall also be applied to the UT of Jammu and Kashmir as well as UT of Ladakh. So these are some of the important provisions with respect to Reorganization Bill of Jammu and Kashmir, which you must remember from your upcoming prelims and mains examination. The purpose of Jammu and Kashmir Reservation Second Amendment Bill 2019 is that whatever benefits is provided under Constitution 103rd Amendment Act 2019 with respect to economically weaker section of the society must be extended to the state of Jammu and Kashmir. Now we know that the Constitution 103rd Amendment Act 2019 provide for 10% reservation over the existing reservation to the members of economically weaker section of the society. So it is in this aspect, it is necessary to amend the Jammu and Kashmir Reservation Act of 2004. It states that the Jammu and Kashmir Reservation Act of 2004 was enacted with a view to provide for reservation in appointment and admission in professional institutions for the members of scheduled caste, scheduled tribes, and other socially and educationally backward classes. And further, the Jammu and Kashmir Reservation Rules of 2005 made under this particular Act of 2004 provided for the manner of reservation to these members of scheduled caste, scheduled tribes as well as socially and educationally backward classes. Another important point to be highlighted is that the expression socially and educationally backward classes includes the residents of backward areas, actual line of control, international border, and social caste. So, it is under this aspect that Jammu and Kashmir Reservation Second Amendment Bill 2019 has been proposed to extend the benefits provided under Constitution 103rd Amendment Act to the members of economically weaker section of the society with respect to reservation in educational institutions as well as with respect to government jobs. Now, after understanding the legality with respect to removal of special status of Jammu and Kashmir, let us go through the important news which has appeared on page number 10 in the editorial section as well as which has appeared as articles. And in this, let us understand what are the different viewpoints as expressed in the article as well as in the editorial. Now, let's talk about this editorial which mentions a wrong way to end. The special status of Jammu and Kashmir was never meant to be permanent, but it should not have been scrapped without wider consultation. So this is one point of view as expressed in this particular editorial. Now this editorial mostly highlights that the political integration of Jammu and Kashmir, which has taken place through the presidential order of 2019, has been marked by executive excess because there was a lack of consultation from the legislative assembly as well as from the people of Jammu and Kashmir. It says that this order of the central government has been marked by executive excess as this was done when there is no legislative assembly in the state of Jammu and Kashmir because of imposition of article 356 of the Indian constitution. So this basically says that this action of the central government is wrong because this action was taken especially when the legislative assembly of the state is not there because of imposition of president's rule under article 356. Another aspect highlighted in this editorial is with respect to the concurrence taken from this legislative assembly, and in this the concurrence on the behalf of legislative assembly, it was taken by the unelected governor or an appointed governor. So this editorial mentions that this also becomes a cause of concern as this concurrence was provided by an unelected governor who again acted on center's behest as the governor holds office during the pleasure of the president. So this is one aspect highlighted in this particular editorial with respect to the concurrence provided by the unelected governor with respect to scrapping of special status as provided under article 370 of the Indian constitution. So it states that the process to change the constitutional status of a sensitive border state has been achieved without any legislative input or representative contribution from its people. So this point of this editorial highlights two aspects, that there was a lack of legislative input because this decision was taken from the concurrence of the governor, who again is a part of the executive, and further without any proper representative contribution from people, or in other words without any proper consultation from the people of Kashmir. So the question raised in this editorial is that can the appointed governor not only replace but also supersede a legislative assembly, and can his concurrence be construed as a concurrence of the people of the state? Another important aspect mentioned in this editorial is with respect to taking away the right to vote of those people residing in the area of Ladakh because that has been declared as a union territory. So it mentions that the move of the central government has taken right to vote of those people residing in the territory of Ladakh as it is now a UT without a legislative assembly. So these are some of the concerns as highlighted in this particular editorial mentioning a wrong way to end. The next article appears on page number 10. It says piecing together Kashmir's audacious roadmap. The new doctrine will have to persuade Jammu and Kashmir that greater integration with India holds promise. Now in this article, the author has highlighted about revocation of Article 370, international perspective, especially with respect to the developments going around in the Central Asian region, devolution of power to local bodies in the state of Jammu and Kashmir, as well as development of the region by empowering the youth. Now, with respect to revocation of Article 370, the article says that even the founding fathers recognized that Article 370 was a transitional or a temporary provision. Hence, the transitional or temporary provision of Article 370 was well recognized in the Indian Constitution. And there was a clear subtext that the revocation of Article 370 of the Indian Constitution will only happen once the approval of the people of state was obtained. Hence, the author says that approval of the people of the state was an essential element of revocation of Article 370 of the Indian Constitution. So, in this aspect, this article highlights that this unilateral move of the central government may be challenged on grounds of procedural infirmities, and also because of the fact that it undermines the basic feature of the compact between New Delhi and Srinagar, which was agreed in 1947. So it basically says that this move of the union government may be challenged in a court of law. In this aspect, the article says that the real test will be how the people of the state, particularly the valley, respond to the situation once the situation is normalized and security cordon is lifted from the state. So, effectively, the article has also highlighted security challenges with respect to the after effect of the decision of the union government to scrap Article 370 of the Indian Constitution. Now, with respect to international perspective, the article says that Kashmir can become more vulnerable considering the larger geopolitics at play in the region, including Central Asia. The article says that Kashmir may become more vulnerable in the area, especially because of the fact that US is withdrawing from Afghanistan and Afghanistan will be more controlled by Taliban. So all these effectively makes the entire region of Jammu and Kashmir, specifically the Kashmir Valley, more vulnerable to these international developments. Now, on devolution of power to local bodies, the article says that since the imposition of President's rule in the state of Jammu and Kashmir, the State Administrative Council has acted to devolve powers to Panchayati Raj institutions in the state. It further says that various central government schemes have been implemented properly, such as Mahatma Gandhi National Rural Employment Guarantee Act, the Pradhan Mantri Awas Yojana, the Midday Meal Scheme, Integrated Child Development Services, and social forestry projects has also been devolved to the panchayats. So we see empowering of Panchayati Raj institution at local levels. It further says that the monitoring and supervision of schools and health institution has also been passed on to the Panchayati Raj institutions, and in addition, panchayats shall also be conducting quarterly social audit of works and programs in their areas. So the move of the union government has empowered the Panchayati Raj institutions to perform at grassroots level. Now, with respect to development of the region by empowering the youth, the article says that almost every popular survey in Jammu and Kashmir reveals that one of the leading causes of youth anger and alienation was nepotism and corruption among the ruling elite. And this anti corruption drive of the government is accompanied by attempts to fast track development to create institutions of academic and extracurricular excellence. And all these efforts will also help in generating skilled employment in the state. Thus, economic integration of the youth of Jammu and Kashmir will also take them away from any radical thought. So, this article highlights that the government of India has to persuade the majority of the people of Jammu and Kashmir that greater integration with India will provide them with more opportunities, more freedom, as well as space, and also strengthen their rights much more than the alternatives proposed by other mainstream political parties or separatist organizations. So, these are the important aspects as highlighted in this particular article as mentioned on page number 10. Now, this article also appears on page number 10. It says, an integration without integrity. More than forced homogenization with India, Kashmir needs a moral disposition towards truth and honesty. Now, this article highlights another perspective with respect to equivalence of a constituent assembly with that of a legislative assembly, and says that a legislative assembly cannot replace a constituent assembly. So, in this aspect, let us understand the viewpoint of this author. So, as highlighted, it says that there is no equivalence between constituent assembly and legislative assembly. So, this article says that the Home Minister had read down the word constituent assembly or replaced the word constituent assembly with that of legislative assembly under Article 370 Clause 3, and states that by reading down the words constituent assembly to mean legislative assembly of the state, the union government has cleverly dissolved the assembly and taken its power or usurped its power, and in effect it is the government that is giving concurrence to itself. So it basically highlights about the aspect of concurrence, that because of a legislative vacuum, it's as if the government is giving concurrence to itself. So in this backdrop, the author has highlighted the importance of Constituent Assembly. It says that it is a body of representatives who are the embodiment of the constituent power that is needed to co-constitute a nation state into existence. So this article says that at the core of the constituent power is democratic consent. This becomes a very important aspect as highlighted in this article. In this backdrop, it highlights that India has derived its legitimacy from its constitution, and the Indian constitution in turn is legitimate because it is supported by a constituent power in the form of democratic consent. Thus, in government's interpretation of the words constituent assembly, there is no acknowledgement of constituent power. So, taking this viewpoint with respect to constituent power and democratic consent, the article mentions that the government's interpretation of the word constituent assembly, there is no acknowledgement of constituent power, or the concept of constituent power is lacking. Further, the article also mentions about Article 370 Clause 2, which says that it clearly mentions that the concurrence of the state government needed to be taken only before the Constituent Assembly was convened. However, there is no mention that the state legislative assembly will have these powers after the dissolution of Constituent Assembly. So there seems to be a legislative vacuum as per this article. So effectively, this article highlights that concurrence of state government should have been taken before the Constituent Assembly was convened. However, there is no mention of the fact that state legislative assembly will have these powers after the dissolution of Constituent Assembly. So on this note, there is a legislative vacuum. The article further mentions that the Constituent Assembly, as the embodiment of constituent power, is what creates and authorizes and gives birth and grants power to the Legislative Assembly. So in this backdrop, the article mentions that there is no equivalence between a Constituent Assembly and a Legislative Assembly. And the step taken by the central government to replace the word Constituent Assembly with Legislative Assembly is procedurally incorrect. So this is effectively what this article has tried to highlight. Now after our discussion, these forms your practice question for the day. What you can do is to take a pause of 5 seconds. The first question says, consider the following statements. Constitution application to Jammu and Kashmir Order 2019 has been provided under Article 370 of the Indian Constitution. Yes, this statement is correct. Second, Jammu and Kashmir Reorganisation Bill 2019 provides for creation of 2 union territories. Yes, this is also correct. So in this, C is the correct answer. Question number 2. Consider the following statements. There has been no mention of instrument of accession under Article 370 of the Indian Constitution. No, this statement is incorrect, as we have seen that instrument of accession has been provided or has been mentioned in the Indian Constitution. Second, Article 370 is a temporary provision under Part 21 of the Indian Constitution. Yes, this statement is correct. So in this, B becomes the correct answer, that is 2 only. Third, consider the following statements about Jammu and Kashmir Reorganisation Bill 2019. First, there shall be 2 administrators for Union Territories of Ladakh and Jammu and Kashmir. No, the existing governor of the state of Jammu and Kashmir shall be designated as a joint administrator or joint lieutenant governor of both the Union Territories of Ladakh and Jammu and Kashmir. So the first statement is incorrect. Second, it provides for amendment of Representation of People Act 1950. Yes, this statement is correct. So in this, B becomes the correct answer. Fourth, which of the following districts are part of Union Territory of Ladakh? Option are Leh, Kargil and Pulwama. In this, the correct option is 1 and 2. So here, the correct answer becomes C. With this, we come to an end to discussion of today's newspaper. Let's move on to the question for the day.